All right, hi, and welcome back. Attorney Steve Vondran here. Welcome to another exciting episode of Litigation Whiteboard. Okay, so what happens if you file a lawsuit in state court and then you lose, you get an adverse decision, and you say, I'm going to appeal this to the federal courts as a violation of my civil rights. Can you do it? Well, let's head to the Attorney Steve Litigation Whiteboard to find out. Okay, so this is general legal information only and not legal advice. We are talking about the Rooker-Feldman Doctrine. Say it with me, Rooker-Feldman Doctrine. Okay, this is a good one for you bar exam people. You're looking on the bar exam, somebody loses in state court and says, I'm going to challenge this as a violation of my constitutional rights, violating my civil rights. I'm taking it to federal court. I'm going all the way up the chain. Can you do that? Let's take a look, okay? So you know in the United States, if you've been watching my videos by now, that there's basically two court systems. There's others. There's small claims and all kinds of different, there's justice courts in Arizona, all kinds of different courts. But let's just talk in general here. We have two different court systems that are operating in the United States, okay? We have our state courts. You know, these may be municipal and superior courts. You have your courts of appeals. You have your Supreme Court for each state. Each state has its own Supreme Court, okay? So typically, a lot of people will file in state court. If they lose, they might take it up on appeal, realizing that there's not a huge chance to win appeals. Doesn't mean don't try it. But I think the numbers are like 10%. They're really low on a chance to win an appeal. That's a whole nother video. And your case can go all the way up to the Supreme Court of your state. Now, in the federal courts, say you have a constitutional question, First Amendment, a copyright infringement case. Those are federal cases. If you have a federal question or can meet the diversity requirements, I have a video out there on diversity of jurisdiction. You can bring your case here in the federal court. Same thing, you work your way up to the Court of Appeals, the Federal Circuit Court of Appeals, and you have your United States Supreme Court, the big enchilada, what we call the court of last resort, okay? So cases can go up this way, cases can go this way. Now, sometimes people will lose over here and they'll want to take their case to a district court. The lower level courts are known as district courts. In federal court, they are trial courts. They listen to cases, they do trials, they do all that stuff. You don't have juries and stuff on appellate court level, okay, or Supreme Court level. So, can you do this? So let's take an example. There was a case where a church was sued for defamation. The church was the defendant in the state court case, and they lost. They lost their case. And so when you hear a case, certain issues are going to come out. You know, was there a false statement of fact? Was there an injury? Was there a publication to a third party? Things like that in a defamation setting. Well, these issues were heard and decided in the Superior Court, leading to an order or usually what we call a judgment. Okay, so usually we're dealing with Rooker-Feldman, we're dealing with final state court judgments. When a decision is final, it has worked its way through the appeals, so forth and so on. It's over. The Rooker-Feldman Doctrine prevents a plaintiff, a litigant, who loses in this case and wants to re-litigate it, as I have here, re-litigate or get this decision reversed. You can't do that. That is a limit on the subject matter jurisdiction of a court, as I have here, subject matter jurisdiction. Okay, now courts need to have both subject matter jurisdiction and in personam jurisdiction over the person. Those are the two things that you're usually looking for. And the Rooker-Feldman Doctrine says you can't do that. You can't get an adverse judgment here and then get upset about it, then go to a federal court, repackage your claim and say, oh, this is a civil rights violation, what this state court did. You can't do that, okay? So that's the general rule. As you know in law, rules are always subject to exceptions. So is the Rooker-Feldman Doctrine, same thing. Now let's take a look at some of these things. And really what the decision is, we don't want to be giving you two bites at the apple. You don't want to litigate one and then go litigate the other. You're talking about the same issues, okay? And when you're dealing with the same issues, you're dealing with the res judicata doctrine. You cannot repeat and retry issues that have already been tried and litigated in other courts. And you can't re-argue claims. It's called claim preclusion. preclusion, or collateral estoppel. Okay, we're going to do another video on these. Don't get hung up on these terms right now. Collateral estoppel and res judicata. We don't want, when you go through the whole court process, we want to give full faith and credit. We want to give full faith and credit and not relitigate and try to get a different decision from a different judge. Okay, it's kind of like a forum shopping deal. So there are exceptions. Let's take a look at it. If you have a habeas corpus case, habeas corpus is basically a criminal law term. Why am I being held? Why am I being held? Why are you holding me against my will? That is something that the federal courts can hear. Okay, so that's an exception. Okay, looking over here at number 1. Number 2, bankruptcy courts. If you have bankruptcy issues, the federal courts have what they call plenary jurisdiction over federal court claims. Okay, so bankruptcy, it's written right there in the Constitution. The bankruptcy courts, the federal courts, are going to be able to look at things, modifying bankruptcy orders and things like that. That is reviewable. Okay, and on all these, make sure you're checking your rules. This is, again, very general, but this gives you some sort of framework to deal with if you're dealing with a case like this. Number 3, what did I miss? Oh, state administrative decisions. So maybe you're over here, you're trying to get a law license or a real estate license. You're going through an administrative procedure. Here, and I'll show you, there's a whole book. There's a whole book I have on administrative procedures, okay? When you go through administrative hearings and things like that, those things, because they're not considered judgments, they're reviewable. Okay, so Rooker-Feldman Doctrine would not preclude the federal court suit. You see how, you following me? 4, if you have a third party that is challenging the state court action, maybe somebody was caught up in an injunction, they lost and they got enjoined on something, and they said, well, I'm going to go to federal court and appeal this injunction, or I'm going to take it to district court or whatever and say it's a violation of my rights. If you're a third party, you weren't the loser in the first case, that's something that is permissible as well. So that's going to be an exception to the Rooker-Feldman Doctrine that limits the subject, that is a limit on the subject matter jurisdiction of the court. So some people call this abstention. Again, res judicata, collateral estoppel. Bear that in mind. Number 5. Constitutional challenges to state statutes. So say you get in here and there's some discrimination lawsuit and there's some law that you're saying, this law is invalid. Let's say, for example, California, the state law is invalid. You lose your case, but you're coming here and you're packaging it as a different case, different issues, not something that's inextricably intertwined, as they say, but a different issue. Now you're challenging the validity, the constitutionality of the statute. That may be an exception as well, okay? And finally, where we have extrinsic fraud in the state court, if you have some conspiracy to violate your rights, if you have an issue of fraud on the court, that is something you can bring up as long as it wasn't brought up and decided already. If it was already brought up and decided, once again, you already had your day in court. Don't go for 2 days in court because you may be barred by the Rooker-Feldman Doctrine, okay? So that's how it works. This is very general. I just want you to have an idea. For you bar review takers, if you see this on your exam, somebody trying to do that appeal from state to federal, ask yourself, were they a party to the action? Did they lose? Was there a final judgment? If this case is still going, parallel proceedings, as I have right here, parallel proceedings are permitted. So, I mean, subject to certain, abuse of process and things like that, but a parallel proceeding could be allowed. So these are general things to think about. You got to look at our court system here in general, how cases are supposed to go through. The other exception is the Supreme Court. 28 U.S.C., that's the United States Code, Section 1257, allows for appeals to the Supreme Court. So if you petition the Supreme Court, we have a video out on this, writ of certiorari, say that 5 times fast. If you can spell it, you get extra bonus points. But the writ of certiorari, if the Supreme Court decides it wants to hear a case, it has the ultimate power. They can hear the case, okay? That's Rooker-Feldman Doctrine in a nutshell. Attorney Steve bringing you the information. Civil litigation, intellectual property law firm. If you need to hire legal counsel, you know where to find us. Otherwise, this is some great tips for you. Feel free to share this video on your social media networks, on your website. Give me a thumbs up. It's not going to kill you. helps me out, or the finger. Just give me the finger and just push that button and we're good to go, okay? Don't forget to subscribe. Hey, folks, this is way better than political stuff. In one ear and out the other. Everybody's telling lies. This is the real deal, baby. Okay? Have a great day. I got to run.